Hello, can you hear me?
The audio conferencing center. Please enter a conference ID followed by pound. If you're the meeting organizer, press star now. You're now joining the meeting.
Hello?
Please wait for the leader to admit you to the meeting. Thank you for you are now joining the meeting.
Hello?
Hey, Kevin, can you hear me?
I can hear you. I'm going to leave the thing on the computer. Do I still need to be in that?
Do you have your video by chance?
Let's click on it. Camera.
Looks like it might be trying, but it's just a black screen.
All right, I will turn it on. Turn it back on. Alrighty. I don't know.
That's okay. Let's just get started. We're gonna review module 1, which we went over last week. Starting at page 7.
Alrighty.
How was your weekend?
It was all right. I didn't do much. I hurt my rib working, and
Oh no.
yeah, I sneezed really hard and it felt like I popped it. So I've been in.
Are you gonna go to the doctor?
No, there really probably wasn't much they could do for me, just besides tell me I have a messed up rib. So
Yeah.
I just dealt with it, and yeah. Didn't do much. I have to call the boss guy to see what our next line of gig is, or the next line of work is, and then go from there. We were supposed to go get a fancy dinner this weekend, but his kids got sick. Everybody who was part of the working this campaign, who works for a company, was allowed to go get fancy dinner, so I thought that was nice.
Yeah, that's nice.
Yeah.
Okay, so let's do this review really quick. Are you on the page in the book, page 7?
I believe so. I am where it says course knowledge assessment. Utilize confirmation objective areas are covered in this module. And then question 1, have to complete the course because the court ordered restoration treatment. That's true.
True or false?
That would be true.
Perfect. What does incompetent to proceed mean?
It means that the judge, the court, has ruled that somebody does not properly understand the legal process to facilitate a proper defense. So they do not commonly understand what's going on, so they're not competent to proceed.
Great. What does ITP mean?
ITP means incompetent to proceed.
Perfect. You can go to trial on your charges blank. Is A, whenever I want, B, never, C, when a doctor finds me competent, or D, when the judge finds me competent?
That would be D, when the judge finds me competent.
Perfect. And number 5, give one reason that competency restoration should be a high priority in your life.
Why not? I mean, get this done, right?
Right? Yeah. Okay, let's move on to page 8, and that will be module 2. The criminal constitutional rights of the defendant.
Do you want me to read out loud?
No, you're okay. We're going to start with the course pre-test and just see where you're at. If you don't know, guess or say you don't know. There's no penalty for getting the wrong answer. So question number 1. The defendant's right to remain silent is the following right. A, the Fifth Amendment, B, the Sixth Amendment, or C, the First Amendment?
That's the Fifth, the right to be protected against self-incrimination.
That is correct. All right, number 2. The right to a speedy trial is A, the Fifth Amendment, B, the Eighth Amendment, or C, the Sixth Amendment?
I believe it's the Sixth.
That's correct.
I actually looked that up because I did not have any clue.
No, that's okay. The requirement that government officials must follow fair procedures before depriving a person of life, liberty, or property is A, the right to sit wherever you want in court, B, due process of law, or C, both A and B?
That'd be due process of law, B.
Correct. And number 4, you can be tried for the same crime, A, only once, B, 3 times, or C, as many times as the judge wants.
It depends. I had a case get vacated, which means they were allowed to re-prosecute me due to the fact it did not get dismissed. So, yeah. It's only be once, A.
Right. Number 5. The rule that prevents evidence gathered illegally from being used in a trial is called A, the no evidence rule, B, exclusionary rule, or C, the judge's rule?
I believe the one that prevents is called exclusionary. The exclusionary rule prevents evidence gathered illegally.
Yep, that is correct. Number 6, you are presumed innocent until found guilty. True or false?
Yes, that is true.
Correct. Number 7, the Miranda warning begins with, you have the right to remain alive. True or false?
Incorrect, false.
Right. Do you know what it is?
You have the right to remain silent.
Right. That's correct. Number 8, you have the right to an attorney at any point in the legal process. True or false?
True.
Yep. And number 9, you have the right to confront and cross-examine all witnesses against you. True or false?
True.
Yep. Perfect. All right. Let's move on to vocabulary. Page 10.
Alrighty, so you want me to read Fourth Amendment?
Sure.
Alrighty. I mean, mean, that's where it starts at the top of the page. So, okay. Review vocabulary terms. Review vocabulary and terms below. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Warrant.
Does that make sense?
The
Fourth Amendment.
I understand that it's supposed to mean that the government's not allowed to go through your papers and all your stuff unless they have a warrant saying for it. And but some say as long as they have probable cause to search, they can search.
Right. So probable cause. Do you want clarification on that, or do you?
It's really not in there with the. I'm scrolling down further, so yeah. What would be the definition of probable cause?
The way I think of probable cause is, if you're driving under the influence, right, and a cop pulls you over, and they're saying you're speeding or you ran a stop sign or something, and that's the first thing they're going after is that you ran this stop sign. But the next thing they see when they get up to your window is that you have a bag of weed in your passenger seat, or your car smells like weed. That would be the probable cause for further search and seizure in that case. Is that the cop believes that you might be under the influence while operating the car. So they can justify searching further for other illicit drugs or testing you for marijuana or alcohol, and therefore giving you further charges if you are under the influence. Does that make sense?
Somewhat. Well, I understand. Well, think about how, like, if it was marijuana or alcohol, all right? So basically, you're not supposed to drive high. You're not supposed to drive drunk. And
right.
When it comes to being drunk, or the suspicion of being drunk, they can say, hey, we're requiring a blood test or some type of test to be performed. Well, marijuana, you really can't do that test.
The probable cause in that case would be, in the alcohol case, would be like, say the officer's like, hey, your breath really smells like alcohol. Have you had any drinks tonight? And you slip up, or you say, yeah, I've had a few beers. If you give the officer a reason to give you the blood test, because you basically admit to having alcohol and then you're driving. So they just want to make sure that you're not over the limit,
Yes.
So probable cause, it's a very loose term.
Yeah, okay.
Okay. Does that make sense?
Yeah, that it's kind of a gray area term that can be used almost wherever they want.
Yeah, there's a clear. They're not going to abuse this. They don't want to abuse probable cause because if it's abused, those charges can be dismissed in court and then officers can get in trouble. But probable cause is just kind of like that first warning sign of another possible thing going on. It's like think of it as like a yellow light.
Okay.
It's like, we're not exactly at a red light where it's like, stop, you did something wrong. It's like, we're slowing down, we're taking a look at things, we want to make sure that everything is good here.
Okay.
Okay, let's move on to warrant.
Warrant, an instrument.
You want me to?
Oh.
Oh, go ahead. Go ahead.
Warrant, an instrument used by a magistrate authority authorizing an officer to make an arrest, seize property, make a search, or carry a judgment into execution. Search and seizure. Warrant requirements and exceptions define how law enforcement officials are to handle the gathering of evidence. The exclusionary rule prevents any evidence gathered illegally from being used at a trial.
Do those make sense?
Yes.
Okay.
It's odd that it says warrant is only issued by magistrate, not a judge. Because I know in the feds that a magistrate and a judge are different.
Right.
Do you know why it says that, or is that just something they put in the book?
I think it's just something they put in the book. I believe a judge can also issue a warrant.
Okay. You want me to read the Fifth Amendment?
Move on. Yeah.
All right. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a pretense or presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. The right to remain silent. Self-incrimination. There is a general right to remain silent, meaning that a defendant does not have to provide testimony against himself or herself. Due process of law refers to procedural fairness and requires you to be given notice of the charges against you and a meaningful opportunity to contest those charges. The defendant must be made aware of all elements and facts of the charge against them, unless there is a statutory exception that can be shown to apply. You cannot be tried twice for the same crime. Miranda warning. Warning usually read upon arrest. In most situations, the police will give the warning only if you are going to be asked questions. However, the police are allowed to ask routine questions. Sixth Amendment.
Perfect.
Okay. I was just going down.
Do you have any questions?
No, I understand it pretty fine.
We'll keep going then.
Okay. Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and causes of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Right to an attorney. A defendant has a right to an attorney at any critical step in a prosecution, not just a trial. It is possible for a defendant to waive the right and represent themselves if they are able to do so. So I know, like, the right to an attorney, but let's say you believe a motion is to be filed and the attorney does not, and you would like the motion to be filed to preserve an argument in case of post-conviction relief is required. So to reserve an argument, like, so it could be heard in appeals. So if an attorney doesn't do that, like, well, then what happens?
If the attorney doesn't file the motion?
Well, or at least, what would that be called? Officially bring it up to the judge so it could be preserved for post-conviction release or any type of appeal.
I'm not sure. I'd have to look a little more into that.
Okay. Jury trial. A public trial by a jury of your peers. At trial, the defendant is presumed to be innocent and cannot be convicted unless jurors are convinced of guilt beyond a reasonable doubt. Speedy trial. You have the right to a timely trial within 6 months in Colorado after pleas of not guilty is entered. If a court is convinced that there has been too much delay, the criminal indictment must be dismissed. This is paused when the defendant is found incompetent to proceed. Appeal. You can formally file an appeal notice with a lower court indicating your intention to take the matter to the next higher court with jurisdiction over the matter, and then actually file the appeal with the appropriate appellate court. This is not a right guaranteed by the Sixth Amendment. Witness. You have the right to confront and cross-examine all witnesses testifying against you. You also have the right to call witnesses to testify on your behalf. Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Additional activities. There are several videos and games that your provider can share with you. Alrighty, so you want me to answer some of those questions?
No, that is it for today. The questions over here are the ones that we answered before.
Yes, that's the same I have. That my pre-test is exactly the same questions as before.
Yep. So we'll just review next week or on Wednesday when we meet.
Alrighty, and I'll see about setting this up properly somehow where I don't have to use the phone and go from there.
Okay, that sounds great.
Awesome. So 2 days from now, Wednesday?
Yep. I'll see you Wednesday.
Thank you very much.
Yeah, thank you. Have a good day.
You too. Bye.
Thanks. Bye.
Here we are, yo. There's a glare on those. 10:30 a.m. to 11 a.m. It is basically 11 a.m. as it is 10:57 a.m. Wanted to go get water, but I was like, no, I could wait. Now, once I think about it, I should have taken the time and grabbed the water, as the water is still needed right now. Have to call employer person and go from there. Oh, dude, I still got to get online and get a fucking lawyer to do the fucking thing. Oh, and I got to check my fucking voucher rebate. Alrighty. Oh, alrighty. Calling it. Peace. Love you. And broadcast quick.